It's an absolute honor to have you this afternoon, and we wish to have a very interactive engagement with you and hope we can learn together as we explore this area of border closure. Now, to start us off this afternoon is our chairperson uh, of the Rule of Law Committee, Mr. Evans Ogada. Mwalimu Ogada, you are welcome to make your opening remarks and then introduce our moderator for the afternoon. Thank you.
Thank you very much, Gabriel. It's always a pleasure to have our colleagues from the region joining us for the annual series of Rule of Law webinars. Thank you very much for those of us who are joining from across the region. We have an eminent panel today that will be moderated by my good friend, Mr. Emmanuel Sebijo from Uganda. We are going to be looking at the effects of cross-border and interstate border, the problems associated with border closures and unilateral actions of state. So without much further ado, let me invite my brother, Mr. Emmanuel Sebijo, to take over from here. Over to you, Emmanuel.
Thank you so much, Evans, and I hope I can be heard loud and clear. Welcome, first of all, to our dear panelists, and also to the audience of advocates, and pretty sure also business persons, politicians, policymakers around East Africa. Thank you so much for joining us today, and I'll be happy to moderate this panel on cross-border and interstate tensions, assessing the implications of border closures and other unilateral actions to regional trade and integration.
All right, to kick us off this afternoon, ladies and gentlemen, we do have a fully composed panel, and our panel will be delving deep into exploring issues regarding border closures and interstate actions. I've seen
Sorry about that.
Would like to introduce our panel. Our panel is quite
recording in progress.
Very eminent persons. Oh, Mr. Sebijo, you're back. It's good to have you. You can take it on now.
He's muted. He's muted. We can't hear him, Emmanuel.
Emmanuel, if you can unmute.
Sorry, just as I sort out this very briefly, I'll be with you in a minute. Okay, we have with us a very accomplished panel, starting with Mr. John Bosco Kalisa. He's the Chief Executive Officer for at the East African Business Council. We then have Professor Thomas Millet, who is a professor at the Kenyatta University and Chair of Public Law. We have Her Worship Christine Mutimura, who is the Deputy Registrar at the East African Court of Justice. And we have Dr. Henry Honoria, who is the Head Law Consulting and Knowledge Practice at ALP East Africa Advocates. Now, we shall begin first with Dr. Henry Honoria, who will help us paint a detailed picture of cross-border closures in the region. He will help us with telling us about their genesis, the potential causes, their key actors. And in this part of the session, we shall benefit a lot from Dr. Honoria's vast knowledge and experience across the region. and he will set the tone for the rest of the discussion. Dr. Honoria, over to you, please.
Thank you, Emmanuel. Unfortunately, I can't seem to activate my video. And I am that generation that is the IT, what's the phrase? Challenged. So I'm not being able to activate the video, but I'm hoping I can be heard.
Yes, Doctor, you can go ahead.
Well, still not. Okay, just to kickstart, as Emmanuel has pointed out, what exactly is the border closures and other unilateral actions in terms of which have created disputes across East Africa? And these are numerous. If we decided to take just a detailed analysis of each, we could probably spend the entire webinar doing this. So I'll just break these these instances into two. There is the basic border closures, and I'll just list a number of them so that we can understand what we are talking about. Literally every country within the East African community, except maybe those which are new to the community, that is Somalia and the DRC, for which we probably don't have that clear documentation since they have just recently joined. But the rest of the other 6 partner states have been involved in this kind of disputes. I think just to tick them off, Rwanda, Burundi, they have had 2 border closures, first in 2015. If you're looking at what caused this or what was the genesis, this followed the disputed re-election of the then president, Nkurunziza. Burundi closed its border with Rwanda due to the emerging unrest. There was alleged Rwanda support to demonstrators and incitement of the coup perpetrators. Now, this continued without really much traction until Burundi returned to stability with the election of a new president, Ndayishimiye, and sort of that improved the relationship. Trade gradually began to increase. But we know that there's a newer border closure in January. Again, Burundi closes its borders allegedly because that Rwanda is supporting what Burundi government regards as a rebel group. So those are 2 involving those 2 smaller partner states of the community. Now, on the other side, you have the Rwanda-Uganda border, which I think those of in Uganda would be familiar with. This started off in early 2019. Again, the causes which you probably need to look at as a community are political differences and tensions. And these related to supposedly Uganda harboring rebel group fighters, detaining or torturing Rwanda nationals in Uganda. So it's basically the political skirmishes between the 2 countries. That closure continued all the way into 2022. And I think Her Worship Mutumira will speak to the matter that was filed before the regional court on this issue of against Rwanda. But then also you have, in the midst of the recent, is the Tanzania-Kenya air traffic restrictions. We normally assume border closures are the physical borders in terms of you are going by road and therefore goods are stopped. Nobody can then cross over. But Kenya and Tanzania showcase that there is also another form of border, that's the air borders. So the air traffic restrictions in early January this year, although this was resolved quickly, but you can imagine the idea that Tanzania had banned Kenya traffic planes from landing in Kenya, in Tanzania. That has its own implications. And then finally, I think, which is the biggest, is what we all faced, the COVID-19 pandemic border closures, where there was not really a problem on a part of any partner state. We were all reacting to a pandemic outbreak. informed by public order and health-related restrictions, but these eventually ultimately affected supply chains, export markets, and this ran from early 2020 to the 2021 and probably early 2022. Now, in terms of the other element that I'll just touch on this, these are the trade export market restrictions. Nobody is closing the border, but they're just basically saying goods in terms of exports from one partner state are not entering into the country. And these are several. We have had Kenya and Uganda. The bulk of these disputes have involved dairy and poultry products, trade restrictions from way back in the mid-20s, but more pronounced from 2020 to the present. I'll just give two examples. The poultry dispute over eggs arriving in in Kenya. And this was probably nobody's, if people had been attentive and not worrying about COVID, they would have noticed that Kenya had amended its excise tax in 2020 to include a tariff on eggs. Recent is a milk coming out of Uganda from Brookside, Uganda, the subsidiary of Brookside, Kenya, that was banned from entering the Kenyan market. We can ask what the reasons were. It's probably political tensions. We have had simmering disputes between Kenya and Tanzania in multi-product trade disputes, from tea, poultry, meat, juice products, sugar products, and often these are involved either denial of import permits, imposition of application fees, excise duty, differential treatment, and the like. And then ultimately we have had the South Sudan, Uganda own set of disputes. I think the latest is the one which happened in 2023, where Ugandan traders found themselves unable to export grain into South Sudan. Of course, this eventually turned out to be an issue of standards. Even when the Uganda standards authorities tested the maize, sorghum, and all that, they found that a huge amount of the goods that were stuck on the Uganda side of the border were actually high on aflatoxins. Those are the issues. Now, I just want to touch on key characteristics, then I can stop there. Now, the key characteristics of these disputes is often that they're unilateral. It says that one partner state then decides to take an action to close borders or restrict entry of goods and products. Secondly, there is no initial efforts, bilateral or otherwise, to address the grievances. At least we know that the Tanzania-Kenya air traffic dispute had talks immediately and were quickly resolved. But the problem is that most times when you have underlying political tensions, the partner states have sort of let the dispute simmer for years. The best example is Rwanda-Uganda, Rwanda-Burundi. And as I said, there are underlying political differences and quarrels, but this needs to be addressed. We need to think of way in which we don't probably let political leadership's differences really affect how trade goes on in the region, because this has a bigger impact than any other thing that can be quickly resolved. Standards keep coming up. Now, the impact of all this is that often when you close a border, is that you lock out a portion of the customs territory. That's the reason why we have the East African Community, that you have a one customs territory where goods should be able to circulate freely. Now, all of a sudden, you are locking out of Burundi, you're locking out Rwanda, you're locking out another country. And these restrictions are often trade-related. They damage trade, especially the trade-related freedoms. We can't move capital, we can't move services, and more in particular, we can't move goods. But also beyond that, the other freedoms are also affected. We can't have free movement of labor. We cannot have people moving to reside and establish in those countries. And these all hamper trade. It was actually demonstrated that during the COVID phase with the trade export restrictions, the flour industry, the coffee industry, tea industry in Kenya suffered huge losses because now they couldn't move these things even if they were producing. But speaking to what I think is the most significant impact is the vulnerable border communities. We often assume that when the border is closed, the well-to-do can probably ship their goods by air if it is a physical border like Malaba, Busia, or the one between Kenya and Tanzania, that the other people well-to-do and high business, high flyers can probably just move these goods by air freight to the other country. But can you imagine the vulnerable border community, the communities that engage in day-to-day cross-border transactions, women, small-time traders, and all that? They lose out. And that has a big impact in not alleviating poverty among those segments of the population. And that's very, very critical. I'll just point out that I used to have conversations with some people out of the Eastern Kenya region, and they told me that the trade wars between Kenya and Uganda on poultry and the eggs, eggs and dairy, impacts themselves significantly because they feel much more closer in Nakuru, in Kisumu and all that to Busia and Malaba and the Ugandan side than they feel with Nairobi. So closing and restricting the movement of those goods out of Kenya, those trade restrictions actually impacts them more than the Nairobi people might actually think. And that is, in this sense, ultimately affects the ability to actually have livelihoods that are sustainable. I will conclude by saying that these trade disputes, the border closures, and all these other unilateral actions have a damaging effect, a far more reaching damaging effect in terms of undermining regional stability and good neighborliness as part of the East African integration experiment. Good neighborliness cooperation is written into the East African Community Treaty. So this does not speak well to how we relate as partner states. We are not very good at managing our political assessment. I'll conclude by reading the statement that the Burundi minister issued when they closed the border with Rwanda to show you how bad it is. He quote, "We have shut down our borders with Rwanda. Anyone attempting to enter will be unable to do so. After having noted that we are the bad neighbor," this is referring to Rwanda President Paul Kagame, "we stopped all relations with him," so it's even personalized, "until he returns to better feelings." So you can see how bad it is. But I'll conclude on that and then I'll come back later. Thank you.
Thank you so much indeed, Dr. Honoria, for setting that tone for the discussion and laying the ground. And of course, we have much appreciated you telling us about the political implications and also about, of course, the advice that you've given about managing communications. And you've opened the discussion up not only to trade in goods, but also to trade in services, capital, etc., which we shall come back to. For now, let us look at the trade impact of these border closures. And next, I will call upon Mr. John Bosco Kalisa, who is the CEO at the East African Business Council, and he will help us explain the biggest problem of border closures from the perspective of regional integration. That is trade restriction or trade limitation. So, Mr. Kalisa, the floor is yours. Please come in.
Yeah, thank you. Thank you very much, our good moderator. Allow me, first of all, to thank the East African Law Society for breaking the ice and organize this webinar on cross-border tensions, barriers, and emerging challenges. And I think before I dive deeper into elucidating or explaining the implication of the border closure and its impact, detrimental impact on business and investment, allow me also to record my appreciation to our heads of state for their unwavering commitment to ensure that East Africa remains the fastest growing region and the fastest in the sense that when you look at the number of reports, recent reports by IMF, World Bank, African Development Bank, they do highlight that the fastest growing region comes, all countries are coming from East Africa. Currently, if I give you the number, the East Africa is growing at an average of 5.1%, ahead of Sub-Saharan Africa, ahead of entire Africa. And when you look at the countries that are posting more than 5% growth, Rwanda comes number one with 7.2%. Of course, also followed by Ethiopia, 6.7%. Uganda and Tanzania, 6.2%. Kenya, around 5.7%. Even Burundi is almost 6% growth. So that demonstrates a high commitment to deeper integration. So despite the skirmishes, the issues highlighted by Dr. Onoria, the region is performing very well in terms of growth numbers. And I always say that the growth is anchored on three strong pillars. One, our deeper commitment to EAC integration agenda. The treaty is very strong and robust. So despite all those challenges, we see that our leaders are still committed to EAC integration, and they're able to hold a number of meetings, engagement, discussion on how best to promote shared prosperity. The second anchor is macroeconomic management. You look at how they've been able to weather or cushion the region from external shocks. Currently, when you look at the numbers, the inflation numbers were almost a double-digit growth inflation, but now it has halved. So you look at all countries, even when you look at the debt distress, some countries were moving toward debt distress, but now they have been able to cushion that. So there is that strong sense of neighborhoodness. The third element is infrastructure development. And I think EAC is quite doing well in terms of cross-border infrastructure. Currently, we are talking about 15 one-stop border posts in place. No other region, whether COMESA or SADC, has those integrated border management. So it is exciting really to see, because having integrated border management means that you are able to reduce time and the cost of doing business. And again, that also infuses into the growth trajectory. I was also looking at the report by published recently by African Development Bank and African Union. When you look at the integration agenda, EAC still does very well. Still does well in terms of the being most integrated region. But when you look at the number of dimensions they are looking at, our trade integration and the production integration dimension, we are not doing well. And that's where I come to the point raised by Dr. Onoria in terms of trade integration. And that is very key and very critical. Those are the two aspects I want to highlight. When you look at our intra-regional trade, EAC intra-regional trade, meaning trading amongst ourselves, we are still at 16%. With all the efforts, with all the investment, with all the macroeconomic convergence criteria, with all commitments, our intra-regional trade is still at 16%. In my view, given all the implementation arrangements that are in place, we should be talking about 40% or 50%. But what hampers that is the emergence of trade disputes, what we call non-tariff barriers, border-related barriers. So we've realized, as Dr. Onoria said, that generally when we are looking at what we call NTB monitoring mechanism, we had more than 200 NTBs across the region. So you can't do business when the borders are not open. And this has been the aspiration of the private sector, borderless East Africa for trade and investment. So this has not been happening because of unilateral decisions, issues related to NTBs, whether they are standard related, tax related, political tensions. All these have a detrimental impact on doing business in South Africa. We are not doing well because of these unilateral decision, because of NTBs, whether they are standard related, whether they are policy related. And that is also a deterrent in terms of investment, because capital is a coward thing, because when you send a negative signal, like the statement my brother has highlighted from the Minister of Foreign Affairs from Burundi, that message echoes to the eyes or ears of investors. No investors will come to put money anywhere where there is such a statement, so such a decisions to cross the border. So that is very detrimental because it sends negative signals to whoever wants to invest in the country, both cross-border investment as well as foreign direct investment. And I can assure you that with our recent numbers, we see that the investment attraction is dwindling given these political tensions and skirmishes. So I think that is very important to take into consideration, that the message you are sending to both local investors, regional investors, and the foreign investors will deter their appetite to invest, because you escalate the risk level of the region. So I think that is the message I wanted to share, that it's not a good way of border closure, because one, it has impact on investment attraction as well as the signal for doing business. Two, also it has another impact on the welfare of our people. And the treaty is very clear: people-centered and market-driven integration. Those are the two overriding principles within our treaty. So once you close the border, it means that the welfare of your people is going to be hampered, is going to be affected. I was looking at the numbers, the statistics before the Burundi closed the border. Rwanda was exporting goods worth $5.7 million to Burundi. And generally, Burundi accounted for 41% of Rwandan export to the EAC region. Burundi was number two, followed by Uganda. So it's not only goods, but also the export of services, export of ideas. Because when we talk about trade, we're talking about movement of goods, services, and ideas. People who are ready to work in Burundi, who are ready to work in Rwanda, who are ready to work in Uganda. So those three aspects are hampered by the border closure. So that has an impact in terms of also deepening poverty level within our region, because the now goods becomes very expensive to the vulnerable community or to the low income segment of our society, because they are able to, even when you look at now what is happening, those companies that are exporting their goods from Kenya or from Uganda, they are using a very long route. They need to go through Tanzania to access Burundi market. So that is very detrimental. It hampers the competitiveness of the regional producers, regional manufacturers, transporters. It has a ripple effect. It has a cascading effect in all actors who are doing business. So I think it is important that really our policymakers refrain from those decisions of crossing borders, and also take into consideration the welfare of the people, because the people, it comes back to the treaty, and the reason why the first EAC really collapsed was that the people's views, ideas were not taken into consideration. So I think it is high time we build and strengthen our. I'm happy that the Deputy Chief Registrar is here. We need to build a strong institution that are able to defend and protect our people. I've realized that when the border between Rwanda and Burundi was closed, all the institutions they kept quiet. No one is talking about it. Even the Council of Ministers, even IARA, even so why? And yet you are supposed to understand and debate these issues. That's how we can be able to solve these issues when we bring them to the limelight of all the stakeholders, the private sector, the civil society, and the policymaker, that we are able to demonstrate the ripple effects or the tremendous impact of the border closure. Let me stop there for the meantime, and I will be able to respond to other questions. Thank you very much.
Okay, thank you so much, Mr. John Bosco Kalisa. And I want to just stay with you for just a few more minutes, maybe 5 minutes, especially on your last point. Of course, when we look at the national setting, whenever the states behave in a way that does not please the nationals, we usually see civil society organizations coming up to defend these rights. And on the regional level, we have seen a similar scenario with civil society organizations like the East African Law Society constantly taking up challenges at the East African Court of Justice against partner states that are breaching civic rights. We also have individuals who are doing the same thing. When it comes to business, however, we have not seen a lot coming from the East African Business Council, for example, to defend business interests and business rights and economic freedoms when partner states behave in such ways as they're behaving. For example, when they close borders, when they ban milk from coming from one country to another, when they ban poultry from crossing over from one country to another, when they ban an airline from landing in at their airport when that airline is from a partner state. Why are we not seeing the East African Business Council coming up to take legal challenges? Because it's one of the avenues through which you can advocate for your businesses. But besides that, please advise us on some of the measures that you're taking behind the scenes so that businesses can be confident, and lawyers, when advising their clients, can also point out these things. Thank you.
Yeah, thank you very much, Emmanuel, for raising that pertinent question. And I wanted really to speak about it. You know, when you read very well the treaty, when you read very well the Customs Union Protocol and the Common Market, there was a need to have a trade remedies committee, where the private sector and civil society and other actors would submit the issues, and they are resolved. Imagine from 2005, we are talking about 19 years down the road. I think it is only one country, I think it's Burundi, who has ratified that trade remedy committee. But other countries have adamantly refused to ratify that. So we have no mechanism. Currently, I think the deputy registrar will speak to that. Currently, even East African Court of Justice do not have that power to deliberate on issues related to trade disputes. I think it is recently, during the recent revision, when they have given that mandate to start deliberating on issues of trade and investment across borders. So we had no channel as the EABC, and we've written numerous letters to the Secretary Generals, to Council of Ministers, but no one is taking that up, and it is clearly encapsulated within the Customs Union that there should be a mechanism to resolve trade-related disputes. So if member states have not ratified, you have no channel as EABC where those disputes would be directed. And I think this comes also to my recommendation, and we urge all the partner states to move quickly and fast track, because this is hampering trade, this is hampering the growth of the region in terms of the contribution of trade to the GDP, as well as the contribution of investment to our GDP. So that is one of the channel. Another thing is that we must empower and support the institution like East African Court of Justice, YALA, because when you look at the current structure, I think the power lies in the hands of the ministers, the Council of Ministers. But other organs of the community are very silent. They are not supported financially. They are not supported in terms of capacity. So I think this is really one of the challenges. I was looking at the European Union Commission and what their court handles. They handle almost 400 cases within 5 to 6 years. But I think if you look at how many cases has ESG received, business related, doesn't mean they are not there. They are numerous, but we have no proper channel. And if we have the channel, does the ECJ have the sufficient capacity at the national and regional level to handle those cases and do the ruling? So I think that the empowerment, strengthening of the institution is cardinal, is pivotal if we want really the region to continue to grow as expected. But again, the private sector, the treaty is very clear that the integration should be private sector led and people-centered. I do always laugh and say, we are given observer status. When I'm invited to participate in the Council of Ministers, I'm not supposed. My mouth is zipped. I'm not supposed. I'm entitled to listen, but I'm not supposed to speak. And I always laugh. So what is that observer status means? We should be co-partners in integration agenda. We need to borrow a leaf from other regional economic. Private sector takes the lead. Even it decides on the agenda of the Council of Ministers, because it is about integration, it is about shared prosperity. And we can only achieve shared prosperity and integration when the private sector is at the forefront, not as a passive player in the integration agenda. And currently we are a passive player. We're just listening. It's like going in the church and you listen to the pastor. We are not given the right platform. So it is to the power of SG or a minister to say, let me give the CEO of EABC to speak. So I think we need to change that. We need to change the structure and also provide that space for private sector to engage and do business and drive the prosperity we want.
Thank you very, very much, Mr. Kalisa, for that comment. And I'm very glad that many of the issues that you've raised, the East African Law Society has managed to balance them out in this session by bringing voices from the areas that will be able to address those. We have an academic voice that is coming up next, and we will also later hear from the East African Court of Justice, and then circle back to Dr. Honoria, who is going to come in with a voice from legal practice. So we should be able to see how to digest that the comments that you have made and see how to put them into perspective. Thank you so much, Mr. Kalisa. Let us now move beyond free movement of goods and into the other economic freedoms. Many times when people think about regional integration or the East African community, they tend to think that it's all about free movement of goods. And so when movement of milk from one nation to another is banned, or when poultry from one country to another is banned, there will be a lot of noise. But when services are banned, we do not see a lot of noise. When one country switches off Facebook, so that service providers who are using Facebook to provide their services from, say, Uganda to Kenya are not able to do that. We do not hear a lot of question from the East African community law perspective, yet those impact the economic freedoms guaranteed by the treaty, etc., when it comes to free movement of capital, free movement of workers, free movement of labor. And at this stage, let me bring in the academic voice, Professor Milei, who is a public law professor at Kenyatta University, but also a very, very, very well-published author on issues to do with regional integration. And I will ask Prof. Milei immediately to help us expand the discussion beyond free movement of goods and into free movement of services, workers, and capital, and really tell us how border closures affect these so that we get that understanding. Thank you, Prof. Please come in.
Thank you so much. Thank you so much, Emmanuel. So when it comes to free movement of people, workers, services, freedom of establishment, we do not need to talk about closure of borders, because the borders are actually closed all the time. Sometimes open only for a very limited group of people, of service providers, And when they open, it is very difficult to make use, actually, of that freedom. And I would like to start answering your question with a dream, free movement. So we imagine what free movement of people, service providers, workers across borders is. We close our eyes. You can imagine a Kenyan lawyer going to Tanzania, advising clients there and representing them, even before Tanzanian courts. We can, or just setting up a law firm. We can imagine, a Kenyan personal trainer, who just goes to Uganda without any formalities, crosses the border, and assists Ugandan gym goers to build, like Emmanuel, for example, Sabijo, to build even more muscle. Or we can imagine a Kenyan singer just going to Tanzania and performing. By the way, I want to apologize for my limited vocal capabilities today. Because of
Given. Okay.
So this is free movement. But we do not have such free movement. We don't have it. We don't have it in practice. We don't have it even on the paper. What we have are narrowly tailored entitlements for a very limited group of highly skilled professionals. Entitlements to be given work permits. So what does the Common Market Protocol, with its annexures, schedules, regulation, what does it do? It sets out certain cornerstones of a procedure which the partner states must use to give the work permit to the applicant from another partner state if the applicant qualifies. So along this bureaucratic process, a limitation of free movement. Now, for whom? Free movement for whom? If you look at the structure of the labor markets in the EAC partner states, we'll find out that 80 to 90% of market participants work in the informal sector. The regulation is clearly not for them. Now, even if you work in a formal sector, you want to enter formal employment in Kenya, where 80% of people, 85, work in informal sector. You must fall under a specific category of either workers or service providers. And the Common Market Protocol adopts a so-called positive list approach, which is an approach copy-pasted from the General Agreement on Trade in Services. So what it is about, what is all about? You are entitled to offer services in another partner states, or to take up employment, or to establish a company if what you are intending to do is listed in a list which has been submitted by a partner state in which you want to take up the employment. And each partner state has submitted that's not quite initial. In 2010, when the Common Market Protocol was enacted, each partner state has submitted a list of categories of services or categories of work, of professions, for which it means to open its market. Now, why do we have why each country has a different list. Each country has a different list because we have a principle of asymmetry in the treaty. According to the principle of asymmetry, or in the course of application of that principle, Kenya, being the biggest economy in the EAC, agreed to open its market for the biggest, largest category of services and jobs. While Burundi, so Kenya has the longest list and Burundi has the shortest list, to put it short. So Burundi was allowed to protect its market, service providers, its labor market, while Kenya was apparently persuaded by its partners, or thought that it's reasonable to open its market for a larger category. Now, I am not sure if, a question to the participants of this forum here, if South Sudan that joined in 2016, or DRC, which joined very recently, or Somalia, has ever submitted such a list. Because if they didn't, yeah, there is no freedom of movement at all, not even on the paper, not even that limited. Now, those lists were submitted in 2010, and they had also different timelines. So there are some categories of workers, of service provider, that could, make use of this freedom in 2012, others in 2014. Anyway, all those deadlines expired in 2015. Now, since 2015, there has been no political push to open the market for new categories of professionals and service providers. So we are still, and this push could be implemented by drafting new lists, new timelines, but that has never happened. And apparently, I've never heard about anybody pushing for it politically seriously. Now, those lists have a very complex system of cross references. So freedom of establishment, I think the main category is freedom of provision of services. Yeah, according to General Agreement on Trade and Services, services can be offered in 4 modes. Yeah, and one of those modes is also establishment, setting up a company. Yeah, it's a mode 3, the movement of service providers, natural persons, mode 4. So those annexes relate to each other, refer to each other. Now, just to give you a short, very short idea about those lists. Yeah, East African Law Society, so I assume there are many lawyers. Kenya, as far as I'm concerned, is the only country that opened its market for lawyers. Yeah, so that lawyers from other partner states may come here, set up their law firms, of course, after they go through all all the necessary procedures. But quite interestingly, Kenya has also clowns on its list. Like a clown. Clown people who entertain other people. And what's the consequence of it? Yeah, so if I am, for example, a Kenyan clown, imagine, and I would like to go to Tanzania to offer my services, keep Tanzanians amused. I am open, I'm entitled to do this once I, of course, get the necessary permits, while a Tanzanian clown coming to Kenya would not have such an entitlement. So the limitation in scope of this freedom is the main reason what I said at the beginning, that actually the borders are closed. only open for very limited category of people. Another story is the red tape. We had a situation here of a person, one of the telcos manager, very experienced manager of one of the Kenyan telecom companies, who was appointed as CEO of one of the Tanzanian telecom company. And actually, she fell under this positive list that Tanzania had submitted. Yeah, telecom manager is one listed, yeah, as a category of workers for whom Tanzanian labor market is open. So first, she was waiting, I think, for 6 months. The work permit application was not, because the application was not processed, or was processed slowly. Most probably the authorities were hoping that she would give up because the process is so slow, but she did not give up. And after many, many months, she was told that she does not qualify, yeah, to be given that work permit. There's also another story. There was a story of a Kenyan singer who wanted to live a dream, which I mentioned at the beginning, you know, moving across border and singing, performing in Tanzania without any formalities, special passes, or whatever those documents required documents are called in the Common Market Protocol regulations and schedules. So she went to Mwanza and performed there, and she was arrested. You I don't know if on the stage or after the stage. Lady was called Lady Maureen, is the name of the singer. And if you are interested, what the Tanzanian audience was deprived of, I can play you. So this is Lady Maureen. She could not perform that because she was arrested. So that's the reality of the free movement of workers, service providers, and freedom of establishment. There's a lot of work to do. Thank you.
Okay, thank you. Thank you so much, Prof. Now, having set that very detailed background on these freedoms and bringing into context what Mr. Kalisa said earlier about the remedies at the East African Court of Justice and the jurisdiction of the East African Court of Justice to deal with disputes regarding those freedoms that you have outlined. Could you take us into what potential remedies that concerned parties can get against partner states at the East African Court of Justice for border closures, and also whether partner states have any justifications, of course, for the state attorneys that will be representing them very vigorously at that court? What would be the potential responses, and how can we balance out those treaty obligations against the partner state justifications for border closures in the treaties at the East African Court of Justice?
Thank you so much. Now, I'm coming back to your initial questions, which also you asked Mr. Kalisa. Generally, I think that business people, that is the other way around, it is more difficult for business people to bring a case against the government than, for example, for a civil society organization. Why I'm saying this? It is because the involvement of the government, or even speaking more broadly, of political elites in the economy. Political elites are very closely linked to economic elites. Sometimes they're even the same. Which basically means that the business people rely on the goodwill of the governments, of the elites, of the officials for doing business. The consequence is that suing the government, be it EACJ or be it national court, may be costly in terms of money, because it might undermine this political goodwill on which the business people rely. That would be my hypothesis. Now, of course, the remedies are available. East African Court of Justice is a very accessible course. I'm sure that Her Worship will talk about it, so I do not want to preempt much. But first, justifications for border closures. So what you have asked, what I was talking about, trade in services, free movement of labor, free movement of establishment, all those regulations, all those annexes of the common market protocols have limitations. No, those freedoms are not unlimited. I'll just give you an example. Yeah, so the typical limitation clause is some sort of also similar to the limitation clauses used in the general agreement in trade and services. So the limitations are possible with regard to public order, public morals, health and human animal health and life, and so on. And those limitations must not be arbitrary. So this is what the common market protocols with all its attachments says, but I don't really even think that it is necessary to belabor, to elaborate on those provisions, because I have never heard that any government even bothered to invoke those exceptions while closing borders, while denying work permits, while limiting freedom of establishment. So why? Why is it so? I think the reason is that all governments treat those commitments to open the market rather as declarations of political intent than binding commitments. And even if we, I think Dr. Onoria mentioned that, even if we look how those border closure issues were resolved, they were not resolved through a judicial process. They were resolved through political deals. I remember we had those stories that Kenyan chickens were burned in Tanzania by the Tanzanian government, while Kenyan government kept refusing entry of Tanzanian trucks carrying rice, with a very funny argument that this rice, the Tanzanian rice, is not the standards of packaging. Kenyan high standards of packaging are not met. Of course, if you stroll through Kenyan supermarkets, you will realize how neatly our rice is packaged. Of course, the argument doesn't make sense. It was about the protection of domestic producers. But now, at some point, we had a media report that Uhuru met Samia, Samia met Uhuru, and they resolved, and then they talked, and now they like each other. So we don't have a problem. So you see, we treat those commitments as political declarations of intent, on the one hand, which can be resolved through political deals, which is, of course, not very good for the business people, because business people expect predictability, a stable environment. And we expect, that's what we do regional integration. We want to have a rule-based system of doing business across the world, or across the region. And now what happens if one day Samia doesn't like Uhuru, or Uhuru doesn't like Samia? So what? Why should business people suffer because? Now, the point I want to make is, the more business people or East African Business Council make use of judicial means of resolving those disputes, the more the faster, the more efficiently those declarations of intent are transformed into legally binding commitments, what they were actually intended to do, and what they actually are, even if they are not treated as such, what they are according to the Vienna Convention on the Law of Treaties. And so please, my appeal would be, let us start litigating those protocols. Let us start litigating those provisions to make them a living legal reality. The cases are there. Of course, the jurisdiction of the court is, as I said, very broad. There's a case of Grand Lac suppliers, yeah, that a company which sued Burundi for seizing their cargo. That was the first case that the damages were awarded, $20,000. They wanted $200,000. So perhaps these damages, a new case law of the court, is some sort of incentive for the business people to actually sue the states for border closures.
Yeah.
This was a case, quite interestingly, the company did not argue the common market protocol but the rule of law. Yeah, principle. The only case before the ACJ where somebody really argued a common market protocol, but please correct me if I'm wrong, was a Samuel Mukira Mohochi case, yeah, where a Kenyan activist, now I think a judge, was denied entry to Uganda. Kio versus Kenya recently, there are some cases on tax discrimination. Yeah, and then the court, it was enough that the court ordered provisional measures, yeah, and the Kenyan government withdrew the regulation, regulation, which was discriminatory towards Tanzanian producers.
Okay.
So the jurisdiction is there. Yeah. Okay. I see, Emmanuel, you want to stop me, so I will allow you to stop.
Yes, I want to interject there because I want you to comment finally within just 2 minutes, so that I can move on to the to Hawashim. Regarding your last point about litigating, of course, with experiences from other parts of the world, the European Union, the Economic Community of West African States, even the WTO itself, it is that these rights on freedom of movement will only remain on paper unless individuals litigate them. Now, of course, we've spoken about the East African Court of Justice, and we shall also hear a bit more about the litigation channels before the East African Court of Justice. But many people will be shaking their heads wondering if it is possible for them to litigate these freedoms at the domestic level. Can we rely on the East African Community protocols, the Common Market Protocol, the Customs Union Protocol, before domestic courts, instead of always crossing to Arusha? Should lawyers start advising their clients to go to the domestic courts to actually challenge based on these protocols? Within 2 to 3 minutes, please, Prof, comment on that so that we can move on to the East African Court of Justice.
Yes, thank you so much. As you know, there is an obligation to give to the East African regional law, community law, the force of law. The very fact that the spot was confirmed by the ECJ in Kiahu Rwanda judgment, I'm sorry for mutilating this name, the mere existence of the preliminary reference procedure in the treaty, so that if you bring a case to a court and a question of the East African Community law arises, the domestic court may ask a question, submit a preliminary reference to the East African Court of Justice. This presupposes that you actually may and should. There are not many cases, though. In Kenya, I am aware of very famous two Sasiru and Kawai cases. Those were cases in which South Sudanese and Ugandan nationals sued the Council of Legal Education. In one case, they were barred from enrolling for the advocates training program. In another case, they were barred from sitting for bar exams. When Kenyan courts said something, but very reluctantly, about the East African Community law. But generally, the tradition in the East African judiciary is a dualistic tradition. Yeah, so the judges are, it's my observation, are more inclined, quite reluctant to resort to international law. This includes the East African Community law, and apply it directly, yeah, in cases that are brought to before them by private litigants. In Kenya, there is a 2010 constitution which many scholars thought would transform the Kenyan system from a dualistic system into monistic system, which every judge is actually entitled to apply international law, and this applies also to Common Market Protocol, for example, and the Customs Union Protocol. However, recently in Me2Bell case, the Supreme Court said it's not the case. International law may be used, I simplify it here a bit, to fill the gaps in the national legislation. Yeah. And if we reduce a Me2Bell case, by the way, a very progressive and necessary judgment, but not in this regard, unfortunately. But if we reduce the Common Market Protocol only as something, a framework meant to fill the gaps in Kenyan national legislation, then it is the petition, yeah, in the national court becomes simply ill-suited, ill-fitted instrument when it comes to challenging non-tariff barriers that Mr. Kalisa was referring to, that arise out of discriminatory legislation, Kenyan discriminatory legislation. Yeah. Okay. What we can do in Kenya perhaps is to challenge some discriminatory administrative practices. Yeah, but this is yet about to be established. Thank you.
Okay, thank you so much, Prof. And I think the biggest takeaway from that is that we have Article 34 of the ESC Treaty, which speaks about the preliminary ruling procedure that you have highlighted, that when a question of East African Community law arises before a national court, then it shall refer it to the East African Court of Justice for a preliminary ruling, in much the same way as when constitutional questions arise before national courts, they must refer them to the Constitutional Court for interpretation, unless that court has provided such an interpretation previously, which is also the case for the East African Court of Justice. So I think the takeaway there is that people should be able to go to the domestic courts because the treaty already envisions such an outcome, that if you go to the domestic court, you can still write to us to give a preliminary ruling, and the domestic court will then follow that ruling in making its final determination. I see Mr. Kalisa's hand is up. I think he wants to make an immediate interjection. Just before we come to you, Mr. Kalisa, I would like to proceed to the East African Court of Justice to hear from Her Worship Christine Mutimura, and then we shall address questions after Dr. Honoria, and questions and comments. Now, we have Her Worship Christine Mutimura, who is the Deputy Registrar at the East African Court of Justice. And so we are very, very lucky today to have a voice from the court, which is very, very central to determining disputes regarding cross-border issues or even border closures. And I'll begin right away by asking Her Worship Mutimura whether the East African Court of Justice is presently handling any matter involving border closures and the details or progress of any such case. But in so doing, I would also like the registrar to highlight to us, because there are many advocates here who will be wondering how they can bring matters before the East African Court of Justice. So I would like her to highlight to us the procedures through which partner states bring their disputes before the East African Court of Justice, but also the procedures through which individuals and civil societies may bring their disputes before your court. Your Worship, please take the floor.
Thank you very much, Emmanuel, and I want to thank the ELS for this opportunity to speak today during this particular panel discussion. Now, before I proceed, I just thought it's important I briefly talk about the East African Court of Justice, and if you will allow, I would like to speak about not only interstate tensions, but also issues relating to cross-border trade that have been brought before our court, because every speaker who's been given an opportunity to speak has been able to touch on that aspect. So I think it's important that I also speak to that.
Your Worship,
Now,
just before you do that, is it possible to turn on your video or that's not possible?
oh, I actually thought it's on.
Okay, thank you so much. It's on.
Yeah. Thank you. So as you all know, the East African Court of Justice is the judicial arm of the community, and it was established under Article 9 of the Treaty for the Establishment of the Community, with the responsibility of ensuring the adherence to law in the interpretation, application of, and compliance with the treaty. Now, there are different parties who can bring matters before a court. We have legal and natural persons who may file at absolutely no cost, as well as partner states who may bring matters against another state before a court. However, the parties who file their matters before a court should be able to file their matters within the 2-month limitation period. Now, looking at partner states bringing matters against another state, this is a new trend that we are seeing at the East African Court of Justice, and it is something that was not happening before we got the first case filed by DRC against the Republic of Rwanda. And towards the end of last year, we have a matter that was brought by the AG of the Republic of Uganda against the AG of the Republic of Kenya. Professor Thomas has also talked about preliminary rulings that may be sought by a national court from our court on the interpretation or application of the provisions of the treaty, or the validity of regulations, directives, decisions, or actions of the community. So these are the different ways that matters can actually be filed before our court. Now, going on to issues of border closure, we have 2 matters that were filed before our court on the border closures, and this was in the case of the Gatuna border closing, if you remember, and that was, the border was closed in 2019, actually on 28th of February 2019. And the matter filed was Kalali Stephen versus the AG of Rwanda. In the matter, the applicants alleged that the respondent state closed its border points with the Republic of Uganda, restricting Ugandan traders and their goods from entering or traveling into Uganda. And this action by Rwanda, he claimed, contravened the treaty and the Common Market Protocol. Now, before court could actually render a decision on this matter, the border was opened by the Republic of Rwanda in March 2022. However, when court decided, it found that the respondent's act of closure of her border point and blocking access to the border contravened the treaty, and the respondent's act of disallowing Ugandan traders from entering the border with goods contravenes the treaty and the common market provisions. Now, as a court, our interpretation of having the border opened before we could actually render justice was also an indication of how partner states also viewed our court. In as much as there was a matter that was filed before our court, I don't think the respondent state was actually looking forward to the decision that was going to be rendered by our court, and opted to resolve the matter before the court had decided on this particular matter. So beyond Kalali, we also had the Eastern African Sub-Regional Support Initiative for the Advancement of Women, and 2 others versus the AG of Rwanda. That was filed also in relation to the Gatuna border closing. In this particular matter, the applicants alleged that Rwanda's action of closing its border with Uganda contravened and violated the Treaty for the East African Community, as well as the Common Market Protocol. Further, that the action also violated the economic rights of women in cross-border trade, and stated that both the governments of Uganda and Rwanda had an obligation to uphold the fundamental principles of the EAC as enshrined in Article 60 and 7.2 of the treaty. Now, unfortunately, in this matter, court found that it did not have a jurisdiction to deal with it because, first of all, it was filed out of time. But this is also an indication of how individuals, this was through, we talked about the fact that individuals can actually bring matters. That is in the case of Kalali, which showed a good example. And in this case, they used the IASI, the Support Initiative for Advancement of Women Organizations. So those are two different categories of parties, but also an indication that there are various ways you could actually file a matter before our court. Now, those are the two cases that the court has actually received in terms of border closure. We have not received any matters filed regarding the current border closure by the Republic of Burundi. However, we have had an instance, we have had several matters that have been filed based on cross-border actions by states which have been found to contravene the provisions of the treaty. I want to talk about two particular cases, and that is the BAT versus the AG of Uganda and the Kio Limited versus the AG of Kenya. These two cases are very similar in the way that they are all challenging the imposition of excise duties on goods from, in the BAT case, it will be from Kenya to Uganda. And in the Kio Limited case, it's imposition of excise duty on glass products from the United Republic of Tanzania. And all these acts were found to be contrary to the provisions of the treaty to the EAC, as well as the treaty of the EAC establishing the East African Community, as well as the Common Market and Customs Union protocols. In the case of Kio Limited, interim orders were issued suspending the application of the Kenyan Excise Duty Act, pending determination on the matter. And when the two courts decided on these particular matters, they found that the imposition of excise duty on goods imported from the respective partner states was discriminatory. As you all know, the treaty, as well as the Common Market Protocol and Customs Union Protocol, provide for national treatment of goods from within the EAC partner states. Now, subjecting them to a different excise duty rate or excise duty, then that is discriminatory in nature. And with the decisions of our court, with eventually the Republic of Kenya and the Republic of Uganda all amended their laws on excise duty, which we found to be a very good response from those particular states, and also showed confidence in the decisions, in the workings of our court. I want to talk about another case, and this was Malema Birizi versus the AG of Kenya. In this case, the applicant alleges that the memo from the Republic of Kenya's Director of Veterinary Services that was dated 14th January 2021, where they were suspending importation of chicken cases and cuts and chicken table eggs for chicken consumption from EAC partner states in pretext of support to producers to recover from disruption in their livestock enterprises occasioned by the COVID-19 pandemic. And another instruction dated 5th March 2021 from the Republic of Kenya's Agriculture and Food Authority Director General, where he was stopping with immediate effect the imports of maize from partner states of Uganda and Tanzania under the pretext that the said maize contained high levels of aflatoxins, was unlawful, and also was an infringement of the key instruments that I've talked about of the community, that is the treaty, as well as the Common Market Protocol. Now, this is a matter that was filed in 2019. However, the court has not yet decided on this matter. And as we speak, this particular ban was lifted, but we are still continuing to see existing bans coming up on the export of powdered milk, as well as the delay in issuing permits for the export of particular products, that is from Uganda into Kenya. Now, allow me to speak to the challenges that the court faces when it comes to determination of these matters. Now, you'll realize a good example is the case of Malema Mabirizi versus the AG of Kenya. And this was it was actually a 2021 matter, and we are currently in 2024. Now, that speaks to the challenge of the delayed determination of matters that the court is currently facing. Despite the fact that we have been given the mandate to resolve these disputes, the delayed disbursement of funds by partner states has been a major impediment for the court to actually undertake its mandate effectively. Now, we are seeing an increase in our backlog, but we are also seeing, because of these decisions that the court is making, an increase in the matters that are being filed by East Africans. So this matters, the decisions of the court have two purposes, or we are seeing two things happening here. We are seeing that East Africans have more confidence in our court, and that is why we have seen states now bringing matters against other states before our court. But with this increased visibility and the delayed disbursement of funds, we have an increasing case backlog. So that means we are not disposing of matters as soon as we should be able to be doing so. And that is why matters like Malema Mabirizi have been overtaken by time. We also see the the oil case that was filed by Uganda against Kenya. We are very glad that that matter was resolved bilaterally, but we were also concerned about how soon we were able to resolve that matter with the increasing backlog. So in as much as we are doing whatever we are doing to influence the improvement in cross-border trade in the region, reduction of tensions between states, the increasing case backlog and the delayed disbursement of funds is an impediment to us undertaking our role. I also want to talk about the fact that there is a lack of proper mechanism at the EAC to ensure the implementation of decisions of the court. So with that lack of proper mechanism, we find that some decisions are made, but there's not much that is done thereafter by states. However, matters that are of an economic nature have been seen to be low-hanging fruits by these states. So you find that states are very quick to implement these decisions, like was the case in BAT as well as the KIO Limited. And JB talked about the issue of our extended jurisdiction on matters of trade, investment, and monetary matters. In as far as this continues to be an impediment for the court in handling matters on, on trade, and in this case, we're looking at cross-border trade matters, the court has found a way of interpreting Article 60 on the basis of upholding the rule of law to actually decide on some of these matters on trade. However, it is important that partner states are also quick to ratify the protocol so that we are able to undertake that mandate on deciding those kinds or the matters of that nature. So looking at that as a court, we have been able to do tremendous work in terms of our jurisprudence on cross-border matters, whether it's trade, whether it's well, I could talk about the decision on the Gatuna case as one of the matters, but our pronouncement in as far as it came way after the opening of the border at least the court was able to pronounce itself on the legality of the closure of the border. So that is my submission so far, and I look forward to speaking more on issues of what the potential remedies are. I also look forward to speaking about what the court has done across partner states in an effort to increase awareness of its work. Thank you.
Okay, thank you, Your Worship. We still have some 10 minutes with you, so I think we can delve straight into those issues. First, if you can explain the potential remedies the East African Court of Justice can order regarding border closures if a party is successful and the border is still closed. What sort of boldness does the court have, and is it able to exercise those powers?
Well, when we talk about boldness, now, in as far as the court is concerned, a role in such a circumstance would be making a decision, whether it is through interim orders, whether it is through a permanent injunction, or whether it's through an order directing a partner state to immediately adhere, or to even award damages where necessary, or even make declaratory orders, although we've received a lot of criticism on the effect of declaratory orders. But now the challenge still comes to what I was talking about. Once a decision of the court has been made, what are the actions following the decision of the court? Especially when when we don't have an existing mechanism to ensure the implementation of the decisions of the court. We've had several cases that have been decided by the ESCJ, particularly cases that have a direct impact on the restoration of rights of individuals. But because we do not have an implementation mechanism, then that has been a challenge for us. The treaty talks about the obligation on states and the council to actually implement decisions, including decisions of our court. However, as long as the ESC does not have mechanisms in place, such as the imposition of sanctions, then there are certain things that we will not be able to achieve as a court, but also as a community. So although the treaty speaks about sanctions, where a partner state has failed to meet its obligation, we don't have a schedule on those sanctions. We are not told how we are actually going to apply those sanctions. So it is those shortcomings that actually, they frustrate our efforts in actually ensuring that justice has been served. And as a court, once a decision has been made, the only thing we can do is actually receive a matter that has been filed again, challenging the fact that a partner state has actually not implemented the decision of the court. But at the same time, it's like a Ferris wheel. We are going round in circles and coming back to the very point. So there's something that needs to be done at the EAC level in regard to how you hold states accountable for not implementing decisions, not only of the court, but also decisions of the council and decisions of the summit as well.
Yeah. Okay, thank you so much, Your Worship, for that very comprehensive comment. I think we can now go into the third question, which is the awareness drive that the East African Court of Justice has conducted across the partner states. We have seen you in almost each of the partner states, speaking to lawyers, speaking to businesses about this court, which has been a very, really uplifting message. And so we would like to know, since we have a lot of advocates on this session today, whether these awareness campaigns have resulted into some positive results. Have we seen litigation rising at the court? But more so, if you could advise as well for the lawyers here, how long it would take for a case to get done from start to finish. You've mentioned the limitations that you have, but within those limitations, what would it take for a lawyer to advise their client that within 1 year, 2 years, your matter will be resolved? Please comment about the awareness and the timelines for justice at the court.
Okay. So the court has been involved in very many activities that are aimed at increasing our visibility. In 2021, we launched the annual East African Court of Justice Judicial Conference that precedes the annual rotational session of the court. So what happens is that the annual judicial conference and the rotational sessions of the court are held in the partner states. Number one, we bring the court closer to the people, but we are also offering a platform that brings together judges from national and regional courts, lawyers practicing in the region and beyond, the private sector, as well as civil society organizations to discuss on current and upcoming matters that affect not only the court, but also the legal and judicial space in the region. So this has greatly influenced the court's visibility. And looking at statistics, I could say at the initiation of the rotational session and the second session of the court that took place in Uganda, we had 80 matters that were filed in 2021. And by the end of 2022, we had 139 matters that had been filed. So that is almost a double increase in the matters that have been filed before the court in just 1 year, which speaks of you know, the increased visibility and what value it brings to the court in terms of having people more aware of the court. And it's not only these activities that we have undertaken. We launched the annual regional media training of editors and journalists from the EAC partner states. And this particular training is not only aimed at increasing the court's visibility, as this engagement to also influence the implementation of the decisions of the court, because we find that the media are a key stakeholder of our court, but also we can also utilize them in the way of naming and shaming. So there are accountabilities in many ways. But the other thing that we have also found of great need and importance is the training of advocates and judges from the region. Now, the training of the advocates has had a primary objective of equipping participants with comprehensive knowledge of the ESC, but also the ESCJ, so that we equip these advocates with the essential skills necessary to apply those particular principles that we share to effectively represent clients before our court. And it is not only representing clients at the ESCJ, but also gap when it comes to judges at the national courts in understanding how well they can resolve matters that relate to cross-border disputes or anything relating to the interpretation of the treaty. And that is where the issue of preliminary rulings comes in. So with this gap, we found that the training of advocates has been very helpful, but we have also the opportunity to train judges from the national courts on how the work of the ESCJ or the mandate of our court. I want to give a good example. You may all be aware of the case of Martha Karua. And there was an advisory opinion that was sought from the Supreme Court on our court's mandate to merit review decisions of the Supreme Court. Now, as soon as the decision was made by the East African Court of Justice, the judiciary of Kenya actually did realize that they did not even understand how exactly the court works. So before the advisory opinion was sought, there was a training that was organized for the judges to understand exactly how our court works and why Kenyans would seek you know, the services of our court to remedy issues that have arisen in the national courts, but they think have not been resolved in the right way, or where they think that their rights, according to Article 6D of the treaty, have not been, recognized or where there's been an infringement. So that is the influence of the decisions we make, but also it also shows the need for the continuous, visibility that needs to be undertaken in the partner states, so that not only the people, but also the judiciaries and other areas or other arms of government are able to understand how we undertake our work.
Okay.
So, and of course, something else I could talk about is our participation on different panels, like this panel, for example, where we are able to talk about our court, its mandate, its jurisdiction, as well as jurisprudence. Thank you.
Thank you so much, Your Worship. I think it makes us very comfortable knowing that the court is taking practical and proactive measures to spread its voice around the region and make us aware about it. So thank you so much once again for joining us here for another such exercise. Let me now circle back to Dr. Honoria to close off the panel with a few interactions. And having heard from the judicial side and also the academic side and previously the business side, I think it's suitable now to hear from the legal practice side. And I want to invite Dr. Honoria first to advise what role the private sector can play in resolving border closures. That is both by private sector, I mean both on the business side, but also the legal practitioners within the private sector. Please, Dr. Honoria, if you can come in with your insights.
Thank you, Emmanuel, again. And it's been insightful. I think I'm hoping that those who have logged on have gotten the benefit of understanding what trade integration and what border closures do for trade. And I like what Professor pointed out about trading services, that often we ignore them when we're looking at the border closures by pointing out that there are actually already difficulties with trading services even without border closures. Of course, border closures make it worse, because if a border is closed, then even whoever wanted to go in there, even through those cumbersome processes of applying for temporary provision of services as a legal practitioner, might find difficulty doing so. But I just wanted to give as a starting point to this particular segment to point out how service delivery, and then I will sort of show how this then fits into the next this segment. When I was in Nairobi sometime, I think June last year, I met a young man who said that he was working as the in-house lawyer for Cafe Javas, CJs, which is it was part of the hospitality segment in Uganda, sector in Uganda. They have moved into Nairobi. They have opened up shop there. That's the beauty of free movement of services, that you can actually go there and establish and then provide the same services you do in another country. Now, interestingly, what he told me is that, okay, we are set up in Nairobi. We're doing well. We have a competitive menu and competitive presence to other food and hospitality service providers in Nairobi. But this was what he pointed out to me, that they have tried to get the pineapples out of Uganda because in their view, the pineapples in Uganda are much sweeter and all that. But they were unable to get that. They were told, no, they can't import pineapples from Uganda. So you can see that even when you set up a service, sometimes that service requires you to get the complementary goods out of the neighborhood. So I can imagine, even if you wanted to set up to bring the eggs, bring the potatoes and all that from the neighborhood, you might still have that difficulty. But just to go back to what the private sector, and that's what CJs and the kind do. And I think probably speak to what also Professor Thomas has pointed out, that if you look at, and what I think Mr. Kalisa pointed out, if you look at not just the intra-EAC trade, I think also let's look at the local businesses within East Africa. How many of them are actually going into the other partner states? I know CJS has gone into Nairobi. I'm just trying to think of, and I know Java House has moved from Nairobi into Uganda. But I'm trying to think of any other East African big business. I know they trade. I know Mukwano Industries moves its soap products and probably cooking oil products into Kenya. But the presence is not as big as that of the conglomerates from outside of Africa. When you look at what is dominating the hospitality sector in terms of hotels, you're probably going to look at brands from outside East Africa. Onama is out of South Africa. They are now present in, I think, Uganda, Rwanda, and I think Tanzania. 4 Points by Sheraton is in Arusha. It's in Ida. It's now in Kampala. But that's an American brand. Same with Protea and all that. So I'm trying to see, why can't we as East Africans do this? But anyway, that's beside the point. Now, that's the private sector. Now, in case of disputes, how they can play a role in resolving disputes, I'll just point out that most East African partner states have apex private sector representative bodies. All of them, literally. I'm just going to point out a few. Kenya has the Private Sector Alliance. Rwanda has a Private Sector Federation. Same Uganda, Tanzania has a Private Sector Foundation. Uganda has a Private Sector Foundation. Uganda. Now, all these are private sector representative bodies. And remember, the community is founded on being a private sector driven integration process. So I would want to see more of these apex bodies playing a big role in managing this dispute. I know as Mr. Kalisa pointed out, the Committee on Trade Disputes is not yet set up. That's where their presence would be felt, and maybe they would be able to engage the partner states in resolving some of these trade wars that are simmering. Maybe the first thing that we need now as a private sector, how can we get the partner states to actually get these committees, which are set out under the EAC Common Market, to be in place, to be put in place? Because they will be critical in terms of managing some of these disputes. And as the East African Court of Justice pointed out, in at least 2 cases, the presence of such other dispute settlement mechanisms like the Trade Disputes Committee on Trade Disputes or Trade Remedies will not affect the court's ability on itself to handle disputes. The other thing I think the private sectors also need to be pushing is to, and this is where they will play their trade advocacy and lobby role, is to push, I think in particular Uganda, to ratify the protocol on extended jurisdiction on trade and investment. I think it's Uganda which is holding up that protocol, so that the court can have that jurisdiction and begin to handle disputes relating to trade and investment. So that role of trader advocacy and lobbying is one that they can critically play. I'm glad that recently the EABC, which Mr. Kalisa leads, issued a statement which sometimes goes a long way to informing partner states, informing the EAC, that they need to be doing the right thing. So in this particular segment, they actually wrote to the Deputy Secretary General of the EAC, pointing out what was going wrong with the implementation of the mandatory electronic cargo tracking node service system. I think the REX, the Regional Economy Electronic Cargo Tracking System. And this was very important because they were pointing out what South Sudan was doing wrong, that was creating more havoc on the movement of goods because trucks were stuck throughout much of March on the border with on the South Sudan border because people are complaining about the high charges that were imposed by the South Sudan Revenue Authority on the service charges for containers entering into South Sudan. Now that's a good example. I'm sure EABC is doing a lot more in this regard, but this is why I'm saying that as the private sector representative bodies, I know EABC is the apex body for all the business private sector in East Africa. Then this needs to be very forceful, and that presence should be shown so that the traders can feel that the representative bodies on trade are actually helping along with this process, helping manage potential disputes, helping address this kind of concerns. And I'll also just point out that maybe also what the private sector bodies need to do is actually to provide leadership in litigating some of the disputes or some of the matters involving trade integration and the kind of barriers. And I'm hoping that that is something they can lead if the protocol on trade and investment becomes operational and the court has that jurisdiction. Because I was looking at the applicants in the reference that was sent to the ESCJ on the Rwanda closure of the borders, and I know they probably as they were civil society, but I would have wanted to see the presence of the private sector apex bodies leading this, because this speaks to the rest that we are addressing these concerns and that this is our role to position ourselves to get the partner states to understand. It probably even speaks highly, and it has a forceful presence implication for partner states that the apex body, the private sector, is actually signaling that this is wrong and that this needs to be addressed in ways that do not lead to litigation before courts.
Okay.
So I think that's just what I can mention in regards to private sector.
Okay. Okay, thank you so much, Dr. Honoria, and I hope that those in those apex bodies or those that are preparing to run for elected office in those private bodies are here listening on some potential manifesto ideas. We need the apex bodies to be more robust in pushing for this. And let me come back to you once again, Dr. Honoria, to conclude just before we hit the 4 p.m. mark, and then we shall go into a 15-minute session of a question and answer before we leave. So Dr. Honoria, I would also like you to comment about the role of legal practitioners in handling and stroke or advising on issues concerning border closures. How are international clients perceiving these closures, and how has the legal market been impacted?
Okay, thanks again. Again, I will start from the foundation that all East African partner states have bar associations. So the leadership should come from there. We might not be able to do this individual as the individual lawyers, but we can still perform our role in terms of providing legal and the transaction advisory to advise clients on how to navigate these disputes, on how to manage cross-border dealings within the context of trade integration under the ESC. But I think the EALS has led this well in terms of providing the leadership on a regional level and within the context of regional integration, addressing the issues that might arise, and has done that since, I think the earliest matter ELS filed was 2007, and they continue to do so, and which is something which is commendable. I would want probably to see The other national bar associations do the same. And remember, we need to be reminded that managing disputes within the context or having them addressed, especially through litigation, which is our purview as legal practitioners, is not restricted to dragging partner states to the regional court in Arusha. It could even be managing litigating these matters at domestic level. And I just want to remind the legal practitioners that the EAC dispute settlement framework is twofold in the sense that you have matters that you can directly take to the EACJ as the regional court, but it's also the matters which you can start at the national level, and then when you feel that, or when the court and the parties feel that the matter requires an interpretation of the EAC treaty, the national court can request a preliminary ruling of the regional court. And once the regional court provides a ruling on the matter requested relating to the treaty, that ruling can then be used by the national court to dispose of the local matter at the national court. So let's not look to everybody, look to the regional court. So coming to that, I think the other thing which we can play as the legal practitioners, and I'm looking at this from the national perspective, is that we can actually do a lot of handling. We can do a lot of advising on issues concerning cross-border transactions, including disputes or matters that might arise from closures of borders. We can advise clients on how to address that. Even the matters that Professor Thomas pointed out, that we are apt as legal practitioners to actually advise clients who are trying to move across on the kind of list of opportunities that are available in a particular country. Are they based on are they based on reciprocity? For instance, I can tell you that Burundi, in spite of its closure of its border with Rwanda in 2023, opened up in terms of its legal practice and notaries practice, but it's on the basis of reciprocity. So anybody from within East African community can actually go on a temporary basis to register and practice before the Burundian courts or offer notarial services within Burundi. So that's something that we need to be aware of, that we can actually advise, but that requires then that whatever advisory we are providing is from an informed viewpoint. We need to frame advisory on grounded understanding of trade law, of East African community law, but also what the law in the East African partner states is, because often that's where the nexus arises, that while East African community law provides the framework for free trade and integration, the national laws are supposed to be the ways in which you can then have those things operationalized. I can tell you, for instance, if you are in the tourist hospitality sector, you would be attentive to the fact that each year Tanzania issues tourism-related regulations which specify differentiated fees for East Africans. So the fee is usually lower, maybe like $15, while the foreigners are paying $50 to enjoy tourist facilities. So those are the things which one could be attentive to. In I think 2015, Uganda amended its trade licensing law. Originally, the law specified that only Ugandans could be engaged in certain types of businesses of trade. The 2015 amendment to the Trade Licensing Act opened that to all East Africans. So anybody who is a member of the East African community can actually come and trade. Now, those are details which we as lawyers need to be showcased, that were grounded in understanding the national laws, understanding the East African community law. I'll just take a number of examples where I think the lawyers failed, and that's why I'm saying we need to have a grounded understanding of trade law. In the recent dispute that emerged and I think this start of somewhere in the middle of last year, the Kenya government under Ruto decided that they needed to import essential goods, and this was, I think, cooking oil, palm oil. Now the government decided to ring fence the imports to a state corporation. Now the lawyers in Kenya quickly rushed to file a judicial review application in the High Court contesting the actions of the Treasury Secretary and the Kenya Revenue Authority Commissioner for Customs, because they wrote all these letters and authored all the relevant administrative decisions to ring fence the importation to that state corporation amid against complaints by all the other business, the private sector. Now, unfortunately, I think the judicial review application was actually not the right approach. And it was thrown out, it was dismissed. Because I would have thought that maybe the lawyers would have read and said, how does this impact on one, trade, and two, competition, free competition, which is a principle of the East African Community Treaty. But also they could have looked at what has been the practice on duty-free importation of goods by Kenya. And I can tell you that the history had always been that the Kenyan government, the Treasury Secretary would issue a notice, a legal notice, in which then they would advertise that Kenya wants to import this amount tonnage of maize, this tonnage of wheat, this tonnage of seed cake, and all those things. And then they would indicate people, they would call for bids, call for suppliers, basically the private sector, to come and offer themselves to provide this importation. Sometimes the legal notice would specify maybe probably pre-qualified companies with indications of how much each tonnage should each bring in. Now, what is also built into those legal notices was the requirement that whoever was bringing in these duty-free imports, that they do so in a manner that meets the standards as imposed by the Kenya Bureau of Standards, KEBS. And most times there should be a conformity, certificate of conformity with standards. So these were details which the Kenyan government was always being, and I don't think anybody ever complained within the private sector. Now, this particular ring fencing, first of all, offended that principle of competition, but also the fact that it was duty-free offended the common external tariff, which had set, I think, included the new band 4, which would have placed such imports at about 35%. So this detail was never really appreciated in terms of, so I think this is where we need as lawyers, even if, as long as we want to begin working around in the context of this growing East African community with a growing jurisprudence, a growing legal framework, that we, even if we need to, we're lawyers, we're legal practitioners, we're expected to know what the law is. We can do self-learning and know what the law is, and that puts us in a better place to advise clients. It also puts us at a better place to litigate any matters, as I said, both domestically and within the East African community. Thank you.
Okay, thank you so much, Dr. Henry Onoria, for those very, very wonderful words of wisdom. I'm sure the lawyers on the session have paid very keen attention and have taken that in. Thank you so much for sharing your knowledge with us. Now, we're going to move into a brief question and answer, but I would suggest that we take it more as parting shots. I will go through the QA that have been raised on the platform itself, on the webinar platform, and then also on the webinar chat. And I will propose that I will make immediate comments, and then I will hand over to the panelists in the sequence in which we started the session, for them to make their parting shots and give any feedback or comments before we close. If anyone has a question, they can post it in the webinar chat or in the Q&A, but I see already there are some questions, so let's address them immediately. First, Tabu Komi suggests that what is the necessity of being in a bloc and other member states are closing their borders? Yes, I think that is a rhetorical question, more of a comment, and it's a question that we all ask ourselves. Thank you for for bringing that out quite clearly. Yes, we should all ask ourselves that question, and we should all ponder on why we purport to be in a bloc, yet members are always closing their borders. I think it's something that partner states and policymakers and government officials on here have to consider very seriously. Second, Maurice Tayebwa says that, is the common market protocol really working? Is it even necessary? It is like everything that is happening currently can be done through stronger bilateral agreements. Yeah, and indeed, the common market protocol has its challenges, and the partner states are making it even more difficult. But as Mr. Kalisa highlighted at the beginning of the session, there are actually many positive things, and there are many positive actions that partner states are taking, and there are many benefits that businesses are taking away from the East African community, from the common market protocol. That includes, one-stop border posts, that includes a common external tariff, that includes non-discriminatory taxes, and even a removal of customs duties on intra-East African trade. So there are a number of benefits, but indeed there are still many challenges. So we're here to see the full potential of the common market protocol. And of course, bilateral agreements within the East African community might be a bit questionable or even controversial, because we already have the East African community. So for partner states to then collaborate on a more on a deeper bilateral level outside the framework of the ESC might be a bit controversial, but it is an avenue that might be explored if it does not affect or counter the objectives of the East African Community Treaty and the protocols there too. Victor Barrett comments that, Professor Thomas, thank you for your articulations on free movement of people. My question is, does ESC protocol on service trade display the inscribed conditions on national treatment and market access part on schedules as per WTO schedules of specific commitment on service supply? Yes, the ESC protocol describes basically couches the free movement of services in national treatment and most favored nation treatment as per the WTO GATS, and goes on to say, under mode 3 and 4 of service supply, what did ESC member states inscribe on conditions on movement of people as service providers, or no conditions at all? And I think the answer here is that once a partner state has put up a condition on movement of services, automatically that condition also applies to the movement of people who are service providers in that service. But I think what I can comment is that most of these limitations were placed by states in 2010, and they should have expired, I think, after 5 years, which or 10 years, if I'm not mistaken. So as we stand today, all of the schedules that were attached to the ESC protocols regarding progressive liberalization of services across the ESC have actually expired, unless partner states have renewed those schedules. But really, as it stands now, the ESC should be fully operational. The common market protocol should be fully operational. But the question remains, is that the case? We have 3 more comments that I'll go through. One from anonymous attendee regarding the case backlog at the ESCJ. The resolution of these disputes at the ESCJ is notoriously slow. So is it right for one to institute a matter under the DSB, that's the Dispute Settlement Body, at the African Continental Free Trade Area to seek justice? And I think the DSB is only an interstate dispute settlement mechanism under the AFCFTA. So individuals are not invited to the party. Only states can bring challenges there too. Individuals can only bring challenges regarding regional or trade issues at the East African Court of Justice, because the ESC Treaty has specifically provided that individuals are invited to the party. The AFCFTA has left it limited only to partner states, and one avenue, as Dr. Honoria has said, might be to lobby the partner state involved to challenge another partner state that is breaching the AFCFTA at the DSB level if the ESCJ is backlogged. And then we have Tabu Kumoi, who is saying that South Sudan is not implementing your decisions. I suppose that is of the ESCJ. What is your take? Maybe her worship, Christine, will come in with that later. I think I'll stop there with the comments. And I also see that in the webinar chat, there have been some comments which have been answered regarding procedures for approaching the East African Court of Justice. Worship Christine Mutumira has already answered that question and provided the link on getting the procedures of the ESCJ. Thank you so much, Your Worship Mutimura. Okay, let us now go to parting shots by Dr. Honoria, and then we shall move on to Mr. Kalisa, who might have had a comment earlier, and I think he'll be able to present it at that stage. And then we shall move on to Prof. Mile and close with our worship, Christine Mutimura. So please, Dr. Honoria, within 2 minutes each, please make your parting shot here. Thank you.
Thank you, Emmanuel, and thanks again for hosting this webinar. It can't be come at a timely manner, as with all the other webinars. The ELS continues to host within the context of ESG trade integration. And my parting shots are essentially on two critical things. One, that we need to get partner states to understand that border closures, trade export restrictions are not helpful. As Mr. Kalisa pointed out, we're at 16% intra-trade, which doesn't really make sense that we're intending to open a market for East Africans. As I pointed out, and I know everybody knows, we're about 300 million plus now with Somalia joining. And that's a huge market. But we're not going to make much sense of it if we are not allowing all the trade border closures and trade disputes don't allow East Africans to actually get access to this broader market. We shouldn't actually be struggling to send more goods to South Africa or to Middle East when we have a quicker market here. And hopefully, once the FTA comes through, the guided trade initiative now has over 20 countries, I think like 28. So that means there are opportunities within the market. So I think the partner states need to get the act together. But in that same breath, I think the private sector needs to get the advocate better, push partner states to realize that there is a downside to this border closure, there's a downside to trade disputes. I think governments are best placed to understand figures. So for each border closure, for each trade dispute, if we can demonstrate that statistics that show that this acts as an inhibitor to trade expansion, trade facilitation, I'm sure our political leaders, notwithstanding that they sometimes behave almost childishly, should be able then to understand that if we are going to talk about a private sector driven and market driven economies, that we need to take as much as possible, remove the trade barriers. Now, the final parting shot is for legal practitioners and any other person who does professional services, that let's take advantage of the opportunities within the East African community and at the continental level to provide the kind of advisory to clients, because too often just like we provide advisory for clients at the domestic and national level, make them understand tax regime, makes them understand business establishment, and therefore it makes it easier for them when they come to us to actually put their investment, put their capital, and put their ideas to local businesses. We should be able also to capacitate them to actually do the same on a regional level. So I always keep telling young lawyers and lawyers generally that let's not be stuck in the cocoon of practicing law, because all that we knew was that we needed to practice company law, banking law, insurance law, and all that. The pond is no longer limited to Uganda or Kenya or Tanzania. It's no longer a small pond. It's now a larger pond of East African Community. You can still do the same thing. Provide advisory for cross-border banking transactions, for cross-border insurance. Insurance and pensions are now the next, how would I put it, part of the ecosystem in terms of investment. And we're no longer just looking at pensions and insurance as just providing cover, as providing retirement benefits. They actually become points for investment. Just like as we become more IT-based economies, digital economies, that's also an area we're expanding into. So how much of the digital economy as a young lawyer or as a practicing lawyer are you actually learning about? And how much are you appreciating the legal regimes for purpose of encouraging your clients to actually embrace cross-border digital services, cross-border transactions, and all that? So I think that's just what my parting shots are. Let's do East African trade from an informed point of view, and from a point of view of being able to actually advocate that partner states do better. Thank you.
Thank you so much, Dr. Honoria, for those very powerful words and a very powerful parting shot. Let me now go to Mr. John Bosco Kalisa to give his parting shot. Mr. Kalisa.
Yeah, thank you. Thank you very much, Emmanuel. And again, I want to reiterate my support to East African Law Society for this exciting engagements and webinars. Really, this is what is required amongst our collaborating institutions, that we need to work together in terms of deepening the understanding of the regional integration. The regional integration itself is not it's not a zero-sum game. It is a win-win situation. So we must embrace that. There's no one should be aiming at making losses, and that is why I think it is always important that we enhance our collaboration, we enhance our partnership, we're able to address the emerging issues. And I also appreciate the submission by Dr. Henry in terms of trading services. And when you look at the growth trajectory of EAC, it's more driven by service sector. The banking sector, the telecommunications, the service sector is recording a double-digit growth. It is one of the sectors that is really anchoring our growth numbers. So we should really work a lot, and I'm happy to say that currently EABC is working with GIZ to come up with a trading service barometer to conduct a detailed audit in terms of the commitments with regard to trading services. So where are the gaps, which countries are doing well, and how do we ensure that those gaps can be adequately addressed? Because we see a lot of a green light in terms of the service growth agenda. I think also what I wanted to highlight is that these border closures are very temporary, and in most cases, it is due to lack of awareness in terms of the benefits as well as the cost implications. I think it is our duty as organization, EABC, ESCJ, East African Law Society, and other actors, IALA, to bring to the attention the repercussions, negative repercussion of the border closure to our business, to our citizens. So sometimes our leaders are not aware about the implications. So we need to bring to the limelight about the implication, what it is taking, and what the partner states are losing. And I think Dr. Henry Ebri articulated that in terms of the benefits. So I'm very happy with what is happening. Perhaps when I raised my hand, I wanted to ask my good sister Christine, in terms of extended mandate of ECJ, whether we still need a trade remedies committee, or we need to strengthen the ECJ to handle trade and investment disputes so that we don't create a kind of a parallel structure, so that as the ABC, I think she highlighted the issues of resources, and that is a challenge across, cutting across. But I think when we work together, we could also mobilize the private sector support to ECJ so that it has that neutrality role. Currently, I don't think really it's a neutral organ, and it is independent organ. Sometimes may be influenced by politicians, but we need to empower it to be a neutral organ so that it is able to handle those cases in a transparent and fairness manner. I think currently we see that is bending towards the policymaker decision, but so I believe that we can work together in terms of enhancing its capacity and competency to deliver its mandate, because the mandate is very clear and it's very strong, well encapsulated within the treaty. But at the moment, I don't think it is doing it, maybe due to resource constraints, but also due to staffing challenges. But I think if it is open for the business, we can work together to mobilize resources and empower it to effectively drive the integration agenda. Otherwise, I want to really submit and appreciate all the eminent panelists, and also thank the team from East Africa Law Society for this engagement. Let's do more of this. And the EABC is committed to really ensure that integration drives its agenda within the specified period of time. Otherwise, there are success stories. There are some positive strides we've made, which we'll be sharing. Asanteni sana, and I wish you a very good evening.
Thank you so much, Mr. Kalisa, and thank you for that assurance from EABC for your continued involvement in regional integration discourses and also activism. Yes, and also I appreciated your question to the South African Court of Justice, which will be taken on by Her Worship Christine. Now, having heard from the legal practitioner's perspective, from Dr. Honoria, and also having heard from the business perspective from Mr. Kalisa, let us now switch to the academic perspective and get a parting shot from Prof. Thomas Mille. Please, Prof.
Thank you very much. I will limit myself to the questions that were asked to me. There were 2 questions in the chat box, which I saw the time running, so I answered them in the chat box. More generally, we have a problem with the free movement of services, freedom of establishment, and free movement of workers. Yes, the Common Market Protocol is fully operationalized as of now, but only with respect to the professions listed in that particular list submitted by the partner states. Now, problem is, number one, the informal sector, as said, 80% of the economy is not adequately addressed by this regulation. It's number one. Number two, I take note of remarks by Dr. Honoria, also by comments in the chat, that some partner states are actually doing more than they are required by the schedule. Just give you the example of Burundi. Burundi, as I thank you very much, Dr. Honoria, for this information, open its market to legal services, to notary services, to advocates. Under the schedule of commitments, Burundi is not obliged to do so. So, well, it is nice that Burundi does it, but Burundi doesn't have to. The same opening, limiting some citizenship requirements with regard to engaging in trade in Uganda. Dr. Honoria said, the Ugandan legislator said, well, also East African citizens may engage in certain activities. But Uganda is not obliged to do so. So what we have are gestures of goodwill by some partner states. Gestures of goodwill can be lasting, but can be also temporary. So today, Burundi opened the market, but tomorrow it may close. Yeah? I am really convinced that we should have some reliable legal framework and a roadmap for liberalization of cross-border trade and services, establishment of workers, which should be legally encapsulated in, I would call it, Common Market Protocol 2.0. Yeah? So that there's reliability, that there's predictability. Yeah? So there's a roadmap, there's a perspective. And I am particularly happy to hear from Mr. Kalisa that the East African Business Council has started working on that. And having said this, I would like to thank you, the East African Business Council, for its good advocacy work, and of course the East African Law Society, that we are having this platform to have a fruitful exchange on these issues. And moderator and my distinguished co-panelists, thank you very much.
Okay, thank you. Thank you so much, Prof, for your wonderful comments and for that clarification. Yeah, thank you for those parting shots. Now let us round up with the judicial voice, and we shall hear from Her Worship, Christine Mutimura, regarding her conclusive remarks, but also a potential answer to the question posed by Mr. Kalisa. Miss, Your Worship, please take the floor.
Thank you very much, Emmanuel. Now, the question that was asked by JB Kalisa was whether we need the dispute mechanism as envisaged in the Customs Union Protocol in place, as well as the East African Court of Justice. Now, looking at the the Customs Union Protocol and what it provides with regards to this mechanism, that particular mechanism also allows for investigations, which the court does not do. However, they are supposed to make their determinations and refer those determinations to the Council of Ministers. Now, when it gets to the council, then that's where decisions are supposed to be made. And for me, that is where the problem lies. Now, and this, I want to tie it to my parting shot. Now, when states set up the East African Community and concluded the various instruments, they made certain commitments that they were to be bound by. However, in recent times, we have seen a complete disregard of these commitments. In some cases, it has been out of ignorance or the lack of knowledge. And for sure, we have had situations where you find a decision maker is totally clueless about some of these instruments and what they provide. And they're representing their states on different platforms, particularly in the region, and still have absolutely no idea about some of these provisions. However, we also have cases where these decision makers are aware of what the respective instruments provide, but have used the advantage of there being gaps in the decision-making process to actually disregard whatever commitments that have been made by the partner states. So I think it is time that as a community, and especially at the moment as we are seeing the continued expansion of the community, to revisit the decision-making process. Because it is this process that has actually deterred the community or states from making the key decisions that are required to actually realize the full integration of the community. So whether we're using the dispute mechanism that we have at the under the Customs Union Protocol, or whether we are looking at the decisions of the court, at the end of the day, it all zeroes down on whether these decisions are being implemented. And I believe that is where the challenge is for the EAC. Now, if you ask me to choose between the dispute, the mechanism that has been provided for under the Customs Union and the court, then I would definitely go to the court, because the court goes through the process to the very end. And the challenge comes when it comes to the decision-making process. And I think at the end of the day, individuals need to have a judicial body make a final decision on whatever decisions that have been made, whether it's for posterity's sake or otherwise. Now, as a court, we also have a challenge that we are currently facing, and it is a reputational challenge. And this is because of the increasing backlog. And we are seeing questions like the ones that have been raised on this platform on, are there any alternative ways that we could, or alternative routes take to have our matters resolved because of the increasing backlog? Now, when we look at the delays in the disbursement of funds, the question still arises, are partner states actually frustrating the work of the organs and institutions of the community through these delays, or is there just a total disregard of their commitments? So we think this is a point where we need to enhance our collaboration with our different key stakeholders, whether it's the bar associations in the region, whether it's the private sector, whether it's the civil society organizations. We are each other's keepers, and it is important that we continue to check or hold the states accountable to enable us realize the integration that we are looking for. Thank you very much.
Okay, thank you so much, Your Worship, Christine Mutimura. Thank you for those wonderful comments. Thank you for closing our panel for us. And thank you for the call that you've made out to anyone who cares to listen, that is about implementation. And we hope that we shall take that message seriously and take it back home to see whichever policy makers or decision makers that we're speaking to, that we're engaging with, they should implement ESC law and also implement the East African Court of Justice decisions and support the ESCJ, both from the government side, but also from the private sector. Thank you so much to all our panelists. I think it is only right to end this session or this webinar on a thank you note. So first and foremost, I would like to thank our panelists for giving us very generously their time and their knowledge and sharing with us their experiences. We do not take it for granted. Thank you very much. I would also like to thank Mr. Evans Ogada, who is the chairperson of the East African Law Society Rule of Law Committee, which is in charge of putting together this webinar together with your team, Gabriel, Emily, Osiemo, and others. Thank you for inviting me to be the moderator in this session. I would also like to thank generally the East African Law Society, the Executive Committee, obviously, and the Governing Council. Thank you so much for always looking out for your membership, and special thanks to the CEO of the East African Law Society Executive Committee, Mr. David Sigano. And my name is Emmanuel Sevijo Semanda. I'm the Dean Faculty of Law at the International University of East Africa, and I'm also the Executive Director at the African Institute of Regional Integration Studies, or ARIS, in Kampala. I've been your host today and your moderator. Thank you, and I will now close this panel. Bye-bye.
Okay, bye-bye.
Bye-bye.
Thank you.
Thank you very much, Emmanuel.
Thank you all. Bye.
Bye.
Thank you. Bye.